and navigating the complexities of the real estate market. We try our best to empower our clients to achieve their property goals with as much confidence as they need. All right. So today we're very fortunate to have Sheryl Aboe here with us. She's a distinguished expert in real estate law who will guide us through two key areas. One, which is an overview of land titles and registration, and two, the importance of engaging with local legal professionals in your real estate ventures, quote unquote, legal professionals in Ghana. We do hope that these points are very insightful to you. And as we move through the session, please feel free to drop your questions in chat. We'll have a Q&A segment at the end where Sheryl will address your queries. So once again, welcome. Thank you for being here. And let's dive right in. Sheryl, can you hear me?
Hi, Andrea. Yes, I can hear you.
Hi, how are you today?
I'm well, thank you.
Thank you
I hope
so
you're
much
doing
for
well. Thank
thank you
you.
so much for leading this webinar.
My pleasure.
Could you just give us a quick introduction to yourself, please?
Absolutely. All right. So, hello, everyone. Thank you once again for joining me and Media GH on this webinar. My name is Sheryl Aboe. I am a qualified legal practitioner in Ghana. I was called to the bar in 2020. I worked with the Attorney General's Department for my first year, and then I went into private practice for my second and third year. And now I am with Nyaho Medical Center in their legal department. So now I'm in house counsel.
Oh, wow, that's amazing.
Thank you. All right. So I would just like to delve right in, if that is okay with you, Andrea.
Yes, of course. Please start.
Okay, so I'll be sharing my screen and then we will be going right into it. Thank you very much, everyone. And
Thank you too.
please feel free to drop your questions, just like Andrea said. If you feel that you need me to explain something further, just hint at me, just draw my attention. I'll be very, very happy to be of help to you. All right, so I'm going to stop my video and then we're going to focus on the slides now. Thank you. All right, can I please get confirmation that you can see my screen?
Yeah, yeah, we can see your screen.
Awesome. So the topic for today is legal aspects of land ownership in Ghana. All right. So I'm just going to give you a quick overview of the presentation and what we are going to talk about. So the first thing we're going to do is describe what an interest in land is, because when you want to purchase land, first of all, you need to know what an interest in land means. That is the most basic thing to know when dealing with land. The second thing is we're going to talk about the types of acquirable interests that exist under Ghanaian law. There are several types of interests all over the world, every jurisdiction and their land system. Okay. And Ghana also has ours. So we have 6 types of acquirable interests, and we're going to be talking about each one. Then we're going to be talking also about the due diligence process, which, in my opinion, is the most important aspect of this presentation and really of the entire land transaction process. So please stick with me till at least the end of the due diligence process stage, because it is so important. The next is we're going to talk about the transfer of the interest in land. So after you've done your due diligence and you're satisfied with your findings and you're ready to go on ahead with the transaction. What what goes into that? What does that mean? How do you acquire the interest? And then finally, we're going to talk about land title registration. You have purchased the land and now you need to register your interest or your title. How do you do that under Ghanaian law? We're going to look at that. All right, are we good to go, please?
Yes, we're good to go.
Awesome. All right. So, what is an interest in land? An interest in land is a right or a bundle of rights a person has in respect of a parcel of land, usually another person's parcel of land. So, if we say a person has title to a land, we're simply trying to imply that the person has ownership of some type of interest in that land. So if you have title to land, we're saying that you own a certain interest in that land. So title is synonymous to ownership. If you have title to something, it means you own that thing. So if you own an interest in a particular land, it means you have the title of that interest to the land. Okay. So there are six kinds of interests in land that exist under Ghanaian law. They are the allodial title, common law freehold, customary law freehold, usufructuary interest, or just the usufruct for short, leasehold interest, also known simply as the lease, and customary tenancy, which is also pretty common. All right, so we're going to explain each of these interests. So the first we're going to talk about is the allodial title. It is considered the highest or the ultimate interest in land. Okay, so in Ghana, allodial title is the highest interest anyone can acquire. So which categories of people can acquire the allodial title? Anybody and everyone. It can be held by the state, a stool or skin, a clan, family, or even an individual. So the modes of acquisition of an allodial title are pretty interesting. So the first one is the compulsory acquisition, where the state, as in Ghana or the Ghanaian government, compulsorily acquires land. So normally it would be if it is privately owned land and the state determines that it is in the best interest of the general public for the state to acquire your land so that maybe it can be used for some public amenity like a hospital or something, then the state will compensate you for the compulsory acquisition of your land. And then the state becomes the allodial title holder of your land. Then there's also conquest. That is in the 1800s or 1900s, where before Ghana was Ghana, probably when we're the Gold Coast, or even um, before we became a nation or a republic. Those days they used to war over land. So the tribe or the side that wins becomes the allodial title owner of the land. Then we have pioneer discovery and settlement. And for that one, just as the name suggests, once you were the first person to come onto the land and you settle on there, you develop it, and you and your descendants continue to remain in possession of the land for 50 years plus, you become the allodial title holder. Then it can also be by gift. Yes. So if you are fortunate enough to be in a family that holds the allodial interest in some piece of land and they want to, they're feeling generous, they can just gift you a portion of the land and you become the allodial title holder. Then purchase. You can purchase the allodial title from someone who previously has been holding it. And then by agreement. So With agreement, it's almost like purchase, in the sense that when the allodial title holder comes into conversation with someone who wants to gain possession and ownership of their allodial title, they may come into some form of agreement. Maybe it might be by barter, a barter trade, or they may just sell it outright to you. Okay, so that's it about the allodial title. Then we have the common law freehold. It arises from a transaction under common law. So Ghana is a common law jurisdiction. So in the world, we have two types of legal systems. We have the civil law and the common law. And the common law originates from the UK. And because we were colonized by the British, we have the legal system, which is the common law system. So that's where the common law freehold interest comes from. It can be held perpetually and it is free from obligations to any other person. The mode of acquisition of a common law freehold in respect of stool and skin lands has been proscribed or has been prohibited since 22nd August 1969. So um, you cannot acquire this interest anymore, especially in respect of stool and skin lands. Then we have the customary law freehold, which arises from a transaction under customary law. So in Ghana, we have every tribe or every clan and their customary law. Okay, so if you want to purchase or acquire a customary law freehold interest, you need to know the specific laws of the tribe or the clan or the family that holds the title. It is subject to the jurisdictional and cultural rights of the stool, skin, clan, or family which holds the allodial title. Okay, so you can go to an allodial title holder and purchase a customary law freehold interest from them. This interest can be held perpetually, which means that once you buy it, it's forever and ever, it's inexhaustive. It is held perpetually, it is inheritable, which means that you can pass it on to your descendants or to anyone. It is alienable, which means that you can dispose of it. Okay, which means that you can sell the interest, you can alienate it, you can sell it, you can dispose of it, whatever you want to do, it's yours without any obligation to the allodial title owner. So the modes of acquisition are by purchase, gift, and inheritance. So we move to the final three, the usufruct. In law school, my law lecturer described the usufruct as the second highest. Remember, we said that the allodial title is the highest or the ultimate interest you can acquire under Ghanaian law. The usufruct comes second in command. So it is acquired in the exercise of an inherent right of a subject of a stool or skin or member of a family or clan which holds the allodial title to use an unoccupied part of the land. Okay, so let me just break that down in a second. So if you are a member of a family or a clan, or you belong to a particular stool or skin that holds an allodial title to a parcel of land, you have the inherent right to occupy any part of an unused part of that land, no questions asked. It is your right. Once you are a subject of a stool or skin, or you're a member of a family or clan that holds the allodial title to a portion of land, you can just go use any unoccupied part of the land and you become the usufruct holder instantly. So modes of acquisition of the usufruct: settlement for a period of not less than 50 years. Not less than 50 years. Okay, and even then you require the permission of the stool or the skin or the family or clan. Okay, it is your inherent right. So the permission is more often than not ceremonial. Okay, you just let them know that I am now occupying this part of our land. And the settlement must have been for not less than 50 years. Then you can boldly say, okay, I possess the usufruct. Then there is also an express grant that can be given by the allodial title holder. So the grant would most likely be in the form of an agreement between the allodial title holder and a purchaser. Then there is also alienation to a non indigent. So if you're a foreigner in quotes, you may be a Ghanaian, all right, but you're a foreigner in terms of the stool or skin or family or clan that is the allodial title holder to the land, and you want to purchase a usufruct from them, you need the written consent. And a lot of times this also comes with performance of established customary obligations. Like I said earlier, every stool or skin, every family or clan, and their traditions, their customs, their way of life. So you need to know what they require of you to do in order to be granted the usufruct. And this is particularly important when you're purchasing land, because sometimes you may think, oh, well, land always appreciates and it's a good investment, which it is. But you really need to give consideration to any terms or conditions attached to the use of the land. Because while you may be okay with the terms or conditions, with the customary obligations that you're required to perform, when you're selling your usufruct, the performance of those customary obligations will pass down to the subsequent purchaser. You need to know, are these customary obligations such that a person who would otherwise be interested in buying my land from me years down the line, would that person be okay with performing these customary obligations? Would it be too cumbersome for a potential buyer? So you need to know these things before purchasing land. The next type of interest we can talk about is the leasehold. It is an interest in land for a certain or ascertainable period. So unlike the usufruct, the allodial title or the allodial interest, customary freehold, common law freehold, which are held perpetually forever and ever. For a leasehold interest, it is for a set period. So you may hold a leasehold for 99 years. That's the maximum number of years a person can hold a leasehold. 99 years, 50 years, 40 years, 30 years, 10 years, 5 years. It is for a definite period of time. It is not forever. It arises from a transaction where a holder of, whether it is an allodial title, customary or common law freehold, or usufruct, conveys an interest in land to another person. And because it is for a definite period of time, it does not exhaust the grantor's interest in the land. Okay, so for instance, if I'm the allodial title owner to a very beautiful plot of land and I grant a lease to someone for 50 years, the grant of the lease does not exhaust my interest, my allodial title in the land. After 50 years, the land will return to me. It is still my land. So other modes of acquisition of the leasehold would be sublease and assignment. So a sublease is, as the name implies, a lease of a lease. So if I've acquired a leasehold interest in a property, maybe 50 years, I can sublease my leasehold interest. I can say I'm subleasing it for the next 10 years. So if you take away 10 from 50, you're left with 40 years. An assignment is when you dispose of your leasehold interest completely. You assign the rest of your interest to another person. So, say I acquired a leasehold for 50 years and I've already had it for about 20 years. So, I want to dispose of the, the, the remaining 30 years. What I will do is that I will prepare an assignment assigning the remainder of my leasehold interest, the term of the interest, to another person. That's an assignment. And then we have finally the customary tenancy. This is an interest in land created by contract. It can be by oral or written contract. It arises from an agreement by a holder of an allodial title, customary or common law freehold, or usufruct to grant another person an interest in land upon terms and conditions. So, a lot of the tenancy agreements that we see these days are customary tenancies. It may involve the payment of rent, sharing of farm produce, that is, if you are renting land for agricultural purposes, or physical partition of the farm or land. So when you rent, anytime you rent a property, a land, a house, that's customary tenancy. So at this point, are we following? I'm just going to check if we have any questions yet. Any questions yet? No? Okay. Then I will continue. So now we are at the most important part, due diligence in land transactions. This is the most critical part of the land transaction process. It is advisable, it is encouraged, strongly encouraged to engage the services of a lawyer at this stage or at this point. So the High Court in the case of Seth Kofi Nyamadi versus Henry Kwesi Colette and the Land Title Registry stated that the law does not tend to sympathize with purchasers who do not do due diligence before giving their monies out. The law does not tend to sympathize with purchasers who do not do due diligence before giving their monies out. So before you enter into a final agreement for the sale or for the purchase of any property, please do your due diligence, or else if you take the matter to court, the court will not side with you. So we're going to cover some aspects of the due diligence process. Kindly note that this is not exhaustive of the due diligence process. There is so much, so much that goes into due diligence. And that is why you should get the help of a lawyer who knows what they are about. But I would always tell people it's best to get a lawyer who is specialized in land transactions or in land matters. But getting a lawyer is better than getting no lawyer at all. So the very first thing to do is to verify the vendor's identity by authentication of their identity card at the applicable state institution. It would interest you to know that There are people who buy land from vendors whose identity they haven't even authenticated at all. They just meet someone who sweet talks them into taking money out of their pockets and putting it into their hands. And they don't even do any background checks on the vendors. Please don't do that. You can and you should demand an identity card or some form of identification from your potential vendor. Please ask for it. Ask for it. You're trying to buy land. And land is not cheap. Wherever you buy it from, land is not cheap. So since you're making this all important investment, get the identity card from your vendor. And then if it is the Ghana card, which is the most I think it's the most highly regarded national ID in Ghana currently. So preferably you get the person's Ghana card, and then you quickly go to NIA and ask them to verify, does is this person really who they say they are? That is the most important. Just making sure that this person is who they say they are. The next thing is physical inspection of the land to ensure that it exists and that it is fit for its intended use. Because whenever you're buying land, even if you're buying it just as an investment, you still need to know that it exists. You still need to know that it exists. And now, if you're buying the land for a particular purpose, maybe you need to purchase land because you want to build your dream home. So, for residential purposes, or for commercial purposes, or for agricultural purposes, you need to go and physically inspect the land and make sure that it is fit for the intended use. Because if you want to farm, you want to make sure that it is arable land, okay? That the land can, or the soil can do what you need it to do for your farm. And I didn't put this down here, but um, another thing to take note of in the due diligence process and um, ensuring that you are getting land that is suitable for your needs is checking the zoning laws of the area in which the land is. Because if you want to acquire the land for residential purposes and that area has been marked as an industrial zone, then yes, you have bought land, which is always a good investment, but now you're going to have to resell it because you do not do your homework to find out whether you are allowed or whether it is permissible under the zoning laws of that area to use the land for that particular purpose. So if it's a residential zone, then obviously you're not going to erect a factory that would be emitting chemicals or gases or noise that are just not appropriate in a residential area. Or you want to farm, but it is in a residential area. You cannot farm in the middle or surrounded by houses, especially when the zoning laws do not permit you to do that. So you need to make sure that the land is fit for intended use and that it exists. The next thing I'll talk about is engaging with owners or occupiers of neighboring lands to learn if there is any litigation or encumbrance on the land. Because the vendor, in trying to sell their land to you, may sell you a dream. And by the time you wake up, you realize that it is too late. So it is always, always wise to talk to anyone in adjoining lands. Just have a conversation with them. What do they know about this land? Do you see people coming onto this land often? Is there any litigation? Is there any encumbrance on the land? I will go into what encumbrance means shortly. You need to know all these things to know what you're getting yourself into, because no one wants to acquire land which is the subject matter of any litigation. It is such a headache. Litigation can be drawn out for years, from 1982 till 2020. There'll still be an unresolved matter in a court of law on land. You don't want to find yourself in that situation. So make sure that the land is unencumbered, whether by litigation or by some other means. The next thing I would advise is for you to inspect the land, or for you to, no, sorry, for you to hire a neutral licensed surveyor to inspect the land and to confirm that the coordinates on the site plan provided by the vendor actually match the reality on the ground. Okay, so even if the vendor says, oh, I've brought this my surveyor to confirm to you that the coordinates on the site plan match what is on the ground, please get your own. Get your own surveyor, okay? Because people can pay anybody to say anything in order to sell their land. So get your own licensed surveyor to confirm that the coordinates on the site plan match the reality on the ground. And finally, I would say conduct a formal search at the Lands Commission. Honestly, after verifying the vendor's identity, conducting a formal search is really, really, really important. You want to ascertain the validity of the vendor's title and to know if there is any encumbrance on the land. So, what is an encumbrance? An encumbrance is simply a claim or obligation against the property. The most common type of encumbrance is mortgage. So, if the vendor has taken out a loan, right, and they've mortgaged that land that they're trying to sell to you in respect of the loan that they've taken, mortgages are always registered. They're always registered. So if you go to Lands Commission to conduct your formal search, you will discover whether there is a mortgage encumbrance on the land. There's also another type of encumbrance known as a lien. A lien is a legal claim on a property by a creditor. So if the vendor is in debt to a creditor, and there's an existing agreement, or even if there isn't an existing agreement, the creditor has been able to hold a lien over the land that they're intending to sell to you. You need to find out, because again, the lien will be registered. So your vendor needs to settle all his debts to make sure that there is no lien on the land before you purchase it. You want a land that is free from encumbrance. Another type of encumbrance that you may not um, really be able to do anything about, but it's still good to know so that you can decide whether it is something you can live with or not, is an easement. An easement is the right of another person to use a portion of your property for access. So I'm sure most of us have been to houses where you need to pass through another person's property to get to your friend's place, or to get to your own house, or to get to another person's property. That right of passage, or that right of way, is known as an easement. Okay, so if the property is in a landlocked area where there is erected properties all over, and there's no way for the person to access a public road without passing through your property, then the person has an easement over your property. It is good for you to know whether there is an easement, which is a form of encumbrance on the land. You need to ask yourself, am I okay with people randomly entering onto my land and using it as their only way of access onto their own land. You need to know if that's something that you're okay with before you go ahead to purchase. So I'm going to read this very important and interesting quote I got from this case. Zambrama versus Mohammed and another in the Court of Appeal. The court held that as a person buying landed property, the third defendant was duty bound to investigate the title of his vendor. Proper investigation depended on each case, but generally included enquiries aimed at establishing the validity of the vendor's title. If no such enquiries were conducted and the title turned out to be defective, the purchaser would be deemed to have notice of the defect. It means that if by conducting due diligence, you would have discovered that the vendor's title was not legitimate, and you did not do that due diligence, you went ahead to purchase the land, the court will say that since you ought to have known, then you know. That's basically what the court is saying. You ought to have known. Therefore, we will deem that you know. Even if in actual fact you do not know, you should have known. So therefore, you know it. And the court is not sympathetic to people who don't do their due diligence before giving monies out. All right. So transfer or purchase of interest. Under sections 34 and 35 of the Land Act, it states that only a legal practitioner is authorized to prepare a conveyance, and a transfer of an interest in land is valid only when it is in writing and signed by the parties or their attorneys. Attorneys here is not referring to lawyers per se, but basically the agents of the parties, people the parties have authorized to sign on their behalf. So people who enter into a land transaction, one, without it being in writing at all, you're in a lot of trouble. It needs to be in writing, or else it is not valid. It is the law that every transaction affecting land must be done in writing before it will be recognized. It has to be in writing. And now, not only must it be in writing, but it must have been prepared by a legal practitioner. And so you usually have the stamp and signature of the lawyer who prepared the conveyance on the cover page of the conveyance. Okay, so whether it is a lease or an assignment, a sublease, a tenancy agreement, whatever kind of conveyance it is, it must have been prepared by a lawyer, or it must have the lawyer's signature and stamp in order for it to be valid, in order for you to be able to even register it at all. Now, there are two exceptions to this rule. There are more than two exceptions to this rule, let me say, but for the purposes of this particular topic, the two relevant exceptions to this rule of having the conveyance in writing is a lease that is for a term not exceeding 3 years, or an oral grant under customary law. So if it is a lease for a term under 3 years, it need not be in writing. Okay, even if the parties intend to renew the lease for a further term, once the initial term does not exceed 3 years, it need not be in writing. And then we talked about the customary law freehold. Remember, we talked about that interest. If we said that it arises under a contract or under a transaction under customary law, and this can be written or oral. Now, the fact that your interest in a particular land is a customary law freehold or the grant was done orally does not mean that you cannot register your title. You absolutely can register a title that has been gotten under an oral grant under customary law. In fact, you can and should do so. Now, when entering into a contract for the sale of an interest in land, as a purchaser, it is important to note what constitutes good title and if the vendor indeed is in possession of a good title. So, good title is one derived from an enactment. Here we're talking about the State Land Act 1962, Act 125, where all public lands are vested in the president on behalf of and in trust for the people of Ghana. So every public land, I think the public lands in Ghana constitute 20%, while 80% of land in Ghana belongs to or is privately owned, privately held, but 20% is vested in the president on behalf of the good people of Ghana. So if you're getting your title from the state, that's good title. Then you can also derive good title from a grant, a vesting order, or conveyance from the state again. So a vesting order basically where whether a testate or intestate passes on. If the person was testate, it means that they left behind a will, and if they um, passed on any landed property to you, when the executors are able to get probate, they would prepare what is called a vesting asset, and then you get it. You get the title to the land. Then there is also a final judgment of a court of competent jurisdiction where there are no conflicting judgments of courts of coordinate jurisdiction. This simply means that there's a lot of um there's a lot of land litigation going on in this country, right? Let's say that finally it comes to an end and you get final judgment from a court of competent jurisdiction declaring that party A has title to this piece of land. If there is no other court of competence jurisdiction, of coordinate jurisdiction, that means there's no other court that has the same level of power or authority to make any declaration on that particular subject matter. If there's no conflicting judgment by any such court on that particular land, then the final judgment of the court will serve as good title. Then finally, we can talk about a grant, an acquisition under customary law, a conveyance, assignment, or mortgage, which is at least 30 years old and establishes that a person is entitled to convey an interest in the land. So it is important that the grant, the conveyance, the assignment, the mortgage is not only at least 30 years old, but that under the mortgage, the grant, the conveyance, the assignment, the person is allowed or entitled to convey an interest in the land. So please take very good note of that. And one thing you can do when you're purchasing land is to, and you should do this, you should demand what is called an abstract or epitome of title by the vendor. This is basically the chronological recital of the history of the vendor's title. So normally you'll find this in indentures or in a deed of conveyance. we have something called the recital. The recital gives you the history of the title or the interest that is being conveyed. It is very, very important to have that. When you get the abstract of the title, you can then do appropriate investigations and raise any requisitions that you may have. Of course, this is over unregistered land. This is over unregistered land. In Ghana, we have two types of land systems. We have the registered land system and the unregistered land system. So if the land you're trying to acquire is in a district or in a zone or an area that is not registered, then you should absolutely request for an abstract of the vendor's title. And if the title is not derived from an enactment or a grant, vesting order, conveyance from the state, a judgment of a court of competent jurisdiction, or a grant, acquisition under customary law, conveyance, assignment, or mortgage at least 30 years old and entitling the person to convey an interest. If the title is not from any of these things, if the origin of the title is not from any of these things listed here, it is not good title. Do not purchase it. Don't purchase land or an interest where the title is not originating from any of these items listed here. All right. Congratulations, you have successfully purchased your land. You have done your due diligence. You're satisfied with the vendor's title and with his identity, and you are satisfied that there is no encumbrance on the land. You are happy to purchase it. You have contracted your lawyer to draft the conveyance, and money has exchanged hands. You now have the title deed to the land. Now you need to register your interest to complete the land transaction process and for your peace of mind. Now there are three systems for the recording and registration of land and interests under our Land Act. They are recording of customary interests and rights by the Customary Land Secretariat. You will remember that I talked about oral grants under customary law, customary tenancy, and the fact that you're not required to put that in writing and you're not required necessarily to register it. However, you should go at least record it at the Customary Land Secretariat. Then there's registration of instruments relating to land. What are instruments relating to land? Those are the written contracts that convey the interest. Okay, so we're talking about a leasehold agreement, an assignment, a deed of conveyance, a sublease, a tenancy agreement, a mortgage agreement, so on and so forth. Even a vesting assent as well is an instrument relating to land that ought to be registered. And then, of course, registration of title, interests, and rights in land. So, the registration process, first of all, you have to ensure that you have all the relevant documentation for your application to register your title. What do you need? You need the written contract itself. Okay, so if it is a leasehold agreement, you need that. Then you need the indenture, which is endorsed by a legal practitioner and proved on oath. You really, really need a lawyer in your land transaction process. If you have done the entire process of acquiring land or purchasing land without the services or without engaging the services of a lawyer, you haven't done the right thing. You haven't actually purchased land. Not really. So you need the indenture endorsed by your legal practitioner, it must be proved on oath, and then a certified site plan by either a licensed surveyor or the director of survey in the survey division of the Lands Commission. All right, so the site plan must also be endorsed by the licensed surveyor. So it must have the surveyor's stamp, it must have the surveyor's signature, and then the dates on which the surveyor actually certified the site plan. Those three things: the stamp, signature, and date. So once you have all your documents in order, you may proceed to present all these documents: the deed of transfer, which is the indenture, certified plan, at the Lands Commission for assessment and payment of the stamp duty. So the Lands Commission would let you know how much you have to pay as stamp duty. Stamp duty is assessed between 0.5 to 1% of the value of the land. All right. So when you're purchasing land, don't just think that, okay, all the money I'm spending is the actual consideration or the actual fee for the land. No. Also have in mind that you're going to have to register your title or your interest, and that comes at an extra cost. So budget for that. So when you have received the 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 amount from Lands Commission that you have to pay as stamp duty, you go and pay it for it to be stamped. Then you resubmit the now stamped instrument together with a filled application form and any other required documents for the registration. So when you're going to apply to register your title or your interest, it comes with an application form, and application forms usually come with application fees when it comes to Ghanaian government agencies. So just have that in mind. The fees change periodically, so I don't know how much it costs now, um but just prepare to pay some good amount of money to apply
Hmm.
for
Hmm.
the registration.
Oh, oh, Cheryl, I just wanted to slide in just
All
for a
right.
minute. We're
Okay.
almost out of time, so I think
Oh,
we
all
have
right.
like 8 to 10 minutes.
I'm
All
almost done. I think
right.
this is the last one.
This is the last slide, I think.
Yeah,
Yeah.
the last
Mm.
slide. So we're almost
Then
done.
we'll have some questions. So thank you guys for being patient. We'll have questions in a bit. Thank you.
All right. Thank you too. So upon successful registration of your title, you will be issued a land title certificate and you will be given an original copy of the land title document. Why should you register your land title? Registration of a person as owner of an interest in land actually vests in you that interest, and it serves as notice to the entire world that now you are the owner of this interest. So if someone wants to now do their due diligence on your particular piece of land, when they go to Lands Commission, they will be able to discover that you are the title owner, the interest owner of this land. Then the rights of a registered proprietor are indefeasible and shall be held by the proprietor free from all other interests and claims, which means that registration is conclusive evidence of your title, and no conflicting subsequent claim can defeat your title. So once you've registered, anyone who comes up to say, "Oh, I have an interest in your land," will be successful because your registration is conclusive evidence of your title. Then the registry, that's a land registry, gives priority according to the order in which instruments were presented to it, irrespective of the date of the instrument. So this is really, really important because you may have bought the land first, and so your instrument may be older. But if someone goes to purchase the same land after you and they go and present their application before you do, the registry will give priority to that person over you. So you need to be quick in registering your land. And finally, failure to register your land may result in summary conviction. It's a criminal offense to fail to register your land. to a fine not less than 50 penalty units and not more than 100 penalty units. You don't want to pay that. I think one penalty unit is now about 25 CDs and some points. You don't want to pay that amount of money. So go register your land right after purchasing it. Real estate cannot be lost or stolen, nor can it be carried away. Purchased with common sense, paid for in full, and managed with reasonable care, it is about the safest investment in the world. This is a quote by Franklin D. Roosevelt. We have come to the end of my presentation. Thank you so much for sticking with me.
Thank you so much. Thank you so much, Cheryl. That was absolutely insightful. That was a load of knowledge. Um, some of us have just joined now, but you are just in time for the
Okay.
questions segment. So,
Oh,
Cheryl, so
yes.
the first question is from Nee. Is hiring a lawyer necessary when dealing with established real estate companies instead of individual sellers?
Yes, you still should get a lawyer because, mind you, it is a lawyer who will prepare the conveyance, and the due diligence process is complex. I tried to break it down and make it as simplified as possible, but there's so much that goes into the due diligence process, and it can become very overwhelming for the layperson or the person who simply doesn't know their way about. They may not even know what to look out for, but an experienced lawyer will know what to look out for. So yes, absolutely, you should still get
Mm.
a lawyer who will present you, someone who can even explain, even if your lawyer is not the one drafting the deed of conveyance, you still need a lawyer who can explain the fine print to you, okay, so that you know that you are really paying for what you want to get.
Right. Okay. So that's all right. That's understandable. That's great advice, actually, because not many people understand what's going on in front of them most of the time.
Right.
So, on to the next person. Paul gave us a scenario. Basically, he says, lawyer, I bought a land in 2005. I think you actually explained this previously, but we'll get on with it.
Okay. All right.
I bought a land in 2005, but did not register. I went to
Mhm.
the Lands Commission to register it in 2017. And to my surprise, the land was registered in 2009.
Mm.
It is a stool land. I then contacted the family that sold the land to me, and according to the family, the registered name at the Lands Commission is not on their records. Wow.
Hmm.
Now, now what are the remedies available to me?
Okay, so first of all, Paul, I'm very sorry that you're in this predicament. Like I explained earlier, the registry does not care whose instrument is older. They only care about who came first. For them, they operate a first come, first served principle. Um, I would definitely need a bit more information in order to advise you holistically. For instance, is there any paperwork, any documentation that you have from the stool? It's stool land, right? So, is there any deed of conveyance? Do you have an indenture with you? We can start from there. If you have one, then maybe you can go and negotiate. Because if someone has already registered the land, you cannot sell it to someone else. You can't sell it to someone else. You can't, because we have something, a principle in law that says that you can only give what you have. You can only part or dispose of what you have. So if you don't have good title, then you cannot dispose of that good title. The best you can do is go back to the stool and renegotiate for another piece of land. Ask them to
Right.
give you another piece of land. Yeah.
No. Well, I hope that helps, Paul. We're really sorry that must be a headache. You've really gone through a lot, possibly. But we have to move on now. God be with you. So Isaac Omari asks, is it a requirement for the director of town planning in your area? In your area, sorry, you can be.
Mhm.
Is it a
Sorry, miss.
requirement for the director of town planning in your area? I think to sign a site
A
after
site
it's signed
plan.
by
I think he's
a
talking about
licensed.
a site plan.
Mm-hmm. Yes, I think site planning
I
and
think he's
uh,
talking about the site plan. Um, Director of town planning. No. So when you're registering, so first of all, it has to be a certified site plan. Okay. So I gave the requirements for a certified site plan. It must either be by the director of survey or a licensed surveyor, not the director of town planning. So the director of survey, if he dispenses or he assigns his authority to sign to the director of the town planning in your area, fine. But it's either the director of the survey division of the lands commission or a licensed surveyor.
hmm. All right. Okay, thank you. Okay, so let's move on to the next one. We are almost out of time right now, but we'll get to as many questions as we can. So Trisha asks, what should one look for when choosing a legal professional for real estate transactions in Ghana?
So you would want someone who specializes in land law, period. You would want that because land can be quite complex sometimes. So you'd want someone who's experienced, who knows the ins and outs of land transactions and land matters in Ghana. But like I said previously, getting a lawyer is better than getting no lawyer at all. So even if it's a general legal practitioner, that is someone who's not necessarily specialized, but the person is qualified to practice law in Ghana, it's best to get someone than not getting any lawyer at all. Yeah. So, Andrea, any other questions?
Right. So I'm so sorry. I thought I wasn't on mute. Sorry. The next question is, um, are there any special obligations for foreigners buying land in Ghana?
So, I wouldn't say special obligations. There's just special provisions, let's say. I did not talk about this, but under the interests or the acquirable interests under Ghanaian law, when you talk about the customary law freehold, um, a foreigner or a non-citizen, let me say, a non-citizen cannot acquire the customary law freehold interest. Okay, it is prescribed for all
Right.
non-indigents in Ghana. Yeah, but
Hmm.
apart from that, once once you're legitimate, yes, you can purchase land in Ghana.
All right. Okay. So just make sure you check your status in the country, and then you can be free to own
Exactly.
land in Ghana just like everyone else.
Yeah,
All right. Okay. So the next question. Thank you so much for being patient and answering all these questions for us.
no
The
problem
next
at all.
question is about squatters. Is from Margaret. Thank you, Margaret. How many years have to elapse for a squatter to take over your property permanently?
12 years, and
Just
you
12
must.
years?
Yes, it's just 12 years. It's just 12 years. But then that is if you haven't done anything to remedy the situation. If you haven't um, dealt with your land, you haven't dealt with the squatters, you haven't asked them to leave, they've just been in peaceful possession of your property for 12 years continuously, then yes, they get your property. They become adverse possessors of your property.
Wow. Okay. So 12 years, everyone. 12 years. Take note. Okay. So from James Boko, sorry, James. He said, thank you for the talk. You
Mhm.
mentioned that there are different registration systems. You also mentioned
Yeah.
that it is based on regions. Can you please tell us which system is in operation in which regions? Thank you.
So it's not based on regions, it's based on districts. It is a little complicated, honestly, Ghana. So you need to find out whether your district has now been assigned as a registrable district. You need to know. So that this is why you need a lawyer. Because if I'm going to talk about the land systems we have, I will not finish. So just know that it is based on districts and not necessarily regions in Ghana. So you
Mm,
need to find out your local assembly whether the area that you intend to purchase land from is registrable or not.
all
A
right.
lawyer
Okay.
can help
Right.
you. Yeah.
Mm, right. Okay. So if I may, I'm just going to take you back to the last question about squatters because somebody really he's Daniel is asking on the 12 years, even if it's registered.
Even if it is registered, signed, sealed, delivered,
Oh my
everything.
gosh.
Yeah. So you need to be diligent over your own land, over your property. You need to
Yeah.
be diligent.
Due diligence is important, everyone. That was the first thing she spoke about. I would just like to tell everyone that anyone interested in these slides for the webinar, they will be made available to you on the website after. It's it's been published by Cheryl, but we will see to it in some way that we can have them available to you. So don't worry about that. Um, okay, so moving on to the next question.
All
I
right.
think this may or may not be our last. David,
Okay.
David, are you here?
Yeah, I can hear you. Please go ahead.
Is it how many more questions can I take?
Oh, how many? I thought you were almost through, so please
Oh,
just
then
go through the rest. Yeah, you're almost through,
oh,
so
all right, okay. Moving on then. All right. So, Yeboah Ebenezer is asking between the title registration holder and the one in possession, who qualifies in law as the true owner of the land?
So obviously the registration holder, because there's possession and there's ownership. So the fact that someone is currently in possession of a particular property does not mean that they have ownership of it. Yeah.
Right. Okay. Okay. Okay, moving on to the next one really quickly. Can can a public open space be sold by the allodial owners? If yes, is can it a public open space, can it be sold by allodial owners?
So I don't know what you mean by public open space. We have public land and private land. Public land is land that is owned by the state. Any other kind of
Right.
land is considered private.
Okay.
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 So
Okay. If in a case of yes, can the public can the public open space land be rezoned?
rezoned. Oh, like
Yes.
an so zoning
oh,
is
what's that?
done at the
By the
government
government.
level. It's not done by private people. No, it's done at the government level. Yes.
Right.
So
Oh, okay. Okay. So, all right. Okay. I maybe so maybe you can give us the person who asked can give us more details about what they're talking about a bit later.
yeah,
Okay.
yeah.
So moving on. Okay, the last person by Harold. Basically he says, I'm about to buy a farmland. It's a family land. I want to know if I can own the land forever after due diligence and registration. So I guess length of ownership.
Okay, so first of all, you need to know what interest your family has in the land. If your family is the allodial title holder of the land, congratulations to you. You're one of God's favorite children. But first, you need to know, you need to know the title or the interest that your family has in the land. That is how you would know whether you can own the land forever. Okay, because for allodial title, customary law freehold, and common law freehold, those are interests that can be held perpetually, forever. So if it's a usufruct, allodial, common law, customary law freehold that your family has, then yes, you can own the land forever.
Wow.
I hope that answers your question, Harold.
I hope that made sense to everyone. Okay. So I guess we've come to a close to of the questions. Thank you so much to everyone who put in a question. If we didn't get to you, I apologize. We're stripped for time right now. So David, would you like to say something before we have a close?
Yeah, I would want to say thank you so much to speaker today. That was amazing. And how you even went through the questions so quickly and gave very crisp and straight to the point answers. Thank you very much. We really appreciate it. We can still see questions coming, but unfortunately, our 1 hour is already past. We are even 11 minutes into our time. So we are very, very sorry to all those who we couldn't answer your questions. And yeah, even from the comments, Sheryl Aboe Esq, you can see people are really they are
Yes.
grateful to the information that you've given. So thank you very much. And we hope to see all of you. And thank you all for coming. Without you, this couldn't have been a success. So we hope to see you next month in our next webinar. Thank you. Yeah, Andrea, you can take over.
All right. Okay. So, Cheryl, I want to just say a huge thank you. You dropped so many facts on me today that I think I need to go hit the books and learn more about the legal aspects of all this because there's so much to actually think about, isn't there?
Yes, there's so much. There's so much. Yes.
Oh, all right. So thank you so much. Thank you again for teaching us all this. It's been a very insightful webinar. Thank you.
Thank you so much for having me, Media GH. I'm grateful for the opportunity to share um, this on this very, very important topic. I can see that there are still a lot of um, questions and comments. So if you if you
We'll
require
definitely have to
further
bring you
information
back.
or clarification, yeah, my name is Sheryl Aboe on all social media sites. So you can
You
just
can
hit me.
follow,
Yeah.
yeah, you can follow her on all social media platforms at Sheryl Aboe, and you can also visit Medea GH on at Medea GH underscore LTD to also get to her if you have trouble finding her. We have her tagged on all our posts, so no problem there. So, okay, so a huge thank you to everyone for joining us once again. We were talking about the legal aspects of land ownership in Ghana. Thank you Cheryl for shedding light on such an important topic. We hope you found this session extremely valuable and you've gotten a clearer understanding of why you need a lawyer to help you through land registrations and all these types of transactions. All right. If you have any further questions or assistance, please don't hesitate to message us on our social media platforms or check out our website at www.medeagh.com. Thank you so much once again. I hope you all have a great evening. Bye.